Welcome. My name is Jerry Oginski. I'm a medical malpractice trial lawyer practicing law here in the state of New York. Thank you for joining me. Today's topic is going to be 5 reasons why your malpractice case won't be accepted by a New York malpractice attorney. The first reason why I think most cases will not be accepted by a malpractice attorney is that we can't prove that the doctor did something wrong. Remember, we have to show that there was wrongdoing by the doctor. And the way we show that is by having an expert confirm that there was wrongdoing. If we can't prove that there was any wrongdoing, despite whatever injuries you or your loved one suffered, it becomes impossible to prove a malpractice case. That's what we also call as liability. Many times a patient or client will call up and tell us this horrible, horrible story and about all terrible injuries that they've suffered, yet if the doctor has not done anything wrong, or there was a complication that was known to possibly have occurred, then it becomes impossible to prove a case. And that's one reason why your case will not be accepted. Another reason why your case may not be accepted is that we cannot prove that the wrongdoing caused an injury. And what do I mean? Many times we are able to show that there is wrongdoing, but that the wrongdoing didn't cause the injury that you're complaining of. For example, let's say you trip and fall on a sidewalk, and the sidewalk may have been defective or raised up a few inches, or maybe there was a hole there. Yes, there was wrongdoing that the sidewalk should have been fixed, and yes, you suffered a problem as a result of it. But take a look at the injuries. In all likelihood, you maybe suffered some bruising, or maybe you sprained yourself, but you know what? In a few days or weeks, that bruising is going to be gone. And that's the third reason why most malpractice cases are not accepted by a malpractice attorney in New York. Because not only are we unable to show that the wrongdoing caused injury, but the injuries may not be significant and or permanent, which is a big, big problem. Now, another reason why your case may not be accepted is if you have lied about a fact in your case, and if it turns out that you have lied about a particular fact in your case, that is the kiss of death to your action. At trial, a judge will give the jury an instruction. It's called falsus in uno. And basically what it means is that if you are found to have lied about any material fact at all, a jury is entitled to disregard all of your testimony or part of your testimony. But I guarantee you that the opposing lawyer is going to make that the crux of his defense and the case against you. So that if you are found to have lied about any aspect of your care and treatment or the extent of your injuries, your case is as good as over, no matter the merits of your case, no matter what. Bottom line is, you cannot lie. You must tell the truth, and you must do it in a straightforward manner as possible. Finally, number 5, the reason why I think your case will not be accepted is if you, the client, insist on running the show. What do I mean? If you tell the attorney, this is what you have to do. You cannot question these witnesses, you cannot look into my background, you cannot obtain these records, you cannot do X, Y, and Z. If you tie the attorney's hands, it will be virtually impossible for the lawyer to adequately represent you, because I guarantee you that your lawyer is going to be missing vital information that he or she needs to know in order to properly prosecute your case. And it's crucial that there are any bumps or warts in your history that your attorney know about it before you ever bring the lawsuit. That's very, very important, and I find that many clients, for whatever reason, are not very forthright with the attorneys. Either they feel something is extremely personal, whether it's financial matters, or it's a personal matter from a medical standpoint. Regardless, the attorney needs to know if there's something in your background that you need to hide or you don't want to tell anybody about it. Your attorney must know about it, because I guarantee you that the lawyer for the doctor or the hospital are going to find out about it during the course of their investigation, whether through investigators, whether doing background search on you, whether looking online, whether doing some other search or obtaining testimony that you've given in the past. I guarantee you it will be the kiss of death in your case if you don't disclose that information to your attorney and be straightforward about it. That's all for today. Thank you for joining me. I'm Jerry Oginski. Have a great day.